So chapter 5 is one of the chunkier chapters. I was talking to somebody earlier and said it's kind of the chapter you have to eat with a fork. Like soup you eat with a fork because it's meaty. There's a lot in it. It's one of the major chapters in this book. If you look at the beginning, there are several key terms in this chapter. A ton of vocabulary that are applicable to your exam. So it's a good one to highlight. There's some new concepts that we're going to introduce here we haven't talked about yet. But first off, let's define an estate. An estate is the degree, quantity, or nature and extent in which a person holds interest in a property. So interest, again, think of these sticks, please, or possession, or this bundle of rights. To put it a little bit more simple, we can say that it's the legally recognized interest that the person has in the real property. Okay? So that's in estate. We have freehold estates, and we have non-freehold estates. When you think of freehold, I mean, this is really the kind of job we're going to do, whether we're auctioneering or helping people buy and sell. It's going to be dealing with freehold estates. Non-freehold estates have to deal with leasing or rentals. Okay? So another way to approach this is that freehold is for an indefinite or uncertain period of time of ownership. That's freehold. Okay? So when I buy a house, I'm not planning on moving out or selling it and moving out on April 17th, 2016. I'm buying a house. And I'm going to live in this house until it no longer works for my situation. Okay? It's for an indefinite period of time. Unless I'm a flipper, where I'm going to buy it and then in 3 months I'm going to put it back on the market and sell it. It's a little different scenario. But your traditional home buyer is going to be buying in this freehold estate. And there's different forms of freehold. The first type of a freehold estate is fee simple. Okay? Fee simple is interest or ownership in property. That's really what it is. It's just having sticks, having ownership. Fee simple. And so below that, we see fee simple absolute and fee simple defeasible. Fee simple absolute is having the most amount of sticks possible. If I own a house in fee simple, I might have a mortgage out on the property, so the bank has some sticks. I might have not paid a subcontractor when he came in and did the electrical work on my house, and so the subcontractor put a lien on my property, so he has a stick now, or she has a stick. So that's fee simple. Fee simple absolute is I have the most amount of sticks I possibly can have. Subcontractor's been paid, the lien's been removed, paid off my mortgage. The only person out there with some sticks is the government. Remember those 4 government powers? They always have those sticks. You can't get those back. So that's fee simple absolute. Fee simple defeasible is ownership with strings attached. I look at it like fee simple defeatable instead of defeasible. It's ownership with strings attached. There's a way it can be defeated. So, for instance, if I approached Adam and I said, I'll sell you Rock Ranch so long as you play country music. If Adam stops playing country music, I get Rock Ranch back. Okay? If I went to Kelsey and said, you can buy Blackacre so long as you marry my son. If she refuses to marry my son, he's only 7, but so if she says yes and then goes back on her word, I get my property back. There's strings attached. It's conditional. Okay? And then we have a life estate. There's some simple definitions at the bottom. They're good ones to highlight. Freehold is another way of saying ownership. And then estate is an interest or a stick in the bundle. So that's just a real basic way of looking at this, just help you bring clarity to these vocabulary words. So fee simple absolute, complete rights with absolute ownership. Again, it's subject to government use and restriction. Defeasible is that defeatable ownership. It's ownership with strings attached. And then underneath fee simple, defeasible, we have two categories. Okay? We have fee simple determinable and fee simple to a condition subsequent. So we're just really breaking this down even further. We're just sinking into the pool of confusion. No. We have fee simple. Underneath that, we have fee simple absolute, fee simple defeasible. Underneath fee simple defeasible, we have fee simple determinable and fee simple to a condition subsequent. Fee simple determinable. Again, fee simple defeasible, remember, is strings attached. And so fee simple determinable, if one of these strings is violated or a condition is violated, then the property automatically reverts back to the original grantor, or you could say owner. So here's an example. McKinnon Park was dedicated to the city, or was given to the city through a fee simple determinable, or I should say fee simple defeasible. So McKinnon Park was given to the city through fee simple defeasible. There's a string attached. The city of Sioux Falls gets to have McKinnon Park so long as there's no alcohol served at the park. And that's a fact, Jack. It's true. So long as there's no alcohol served. But if the city would put on a city function, bring in the Coda beverage and have alcohol served, then Miss McKinnon, which has passed away, so her heirs would get the property back. And if it was set up on a fee simple determinable, it would automatically revert back to them. They get it right back. W.H. Lyon Fairgrounds, it's the same way. Given to the city, so long as it's used for an agricultural purpose. Okay? So there's conditions, there's these strings that are attached. So in a fee simple determinable, if the strings are cut or broken, conditions aren't met, it automatically reverts back to the heirs. And a fee simple condition subsequent, if the conditions are broken, the terms aren't met, it's going to require a court action. It's going to require going to court, hiring attorneys, and possibly a lengthy, drawn-out legal process to get the property back. So how I look at it is fee simple condition subsequent, it's a mouthful, right? It's a complicated word, so it's a complicated process to get it back. See, fee simple determinable, it automatically comes back to you. But the fee simple condition subsequent, again, complicated, lengthy word, it's a complicated process to get the property back. Requires court action. And remember, the third one listed under the freehold estate was a life estate. Okay? So, we're going to do an example of a life estate up here on the board. And this is actually pretty accurate in the sense that this is how my dad has his life estate set up. So I get to use kind of a real world example to illustrate a life estate. So my parents got divorced about 8-9 years ago. Okay, so my parents are no longer together. My dad remarried a few years ago, and his wife is retired. His wife and him, their primary source of income is the farm, and then of course retirement. But that's the primary way that they make money, is through the farm. So my dad set up a life estate so that if something should happen to him, she could continue to get revenue off the farm. But when she passes away on a life estate, there's what's called the remaindermen, and those are the people or family members or heirs that get the property once that person, which is my dad's new wife, or they call them the life tenant, once they pass away, then the property now becomes the heirs or the remaindermen or us kids. So let me draw this out. So my dad, so here's our life estate. So my dad's name is Pete, and he is on the life estate referred to as the grantor. Okay? Could be a term you would see on an exam. So he gives the property to Mary, which is his new wife, for Mary's life. Then when Mary passes away, then it goes to us kids. This creates really a win-win. Because if my dad happens to pass away before Mary, she can still be taken care of again from the revenue from the farm, but when she passes away, the farm automatically comes to my dad's heirs, which is me and my sister. Okay? My dad is farming the homestead that he grew up on. In fact, I grew up in the same house that my dad grew up in. And it's his desire, as well as mine, that that stays in the Johnson family. If I was to be farming today, I'd be a fifth generational farmer. And so that part of that neck of the woods is very important to our family. So it creates a win-win for my father, because he can take care of Mary. When Mary would pass away, then it continues on in the Johnson name. So there's my dad as the grantor. Mary is going to be referred to as the life tenant. Her life is called the life measure. And then us kids are called the remaindermen. And we also have what's called reversionary interest. As well as the grantor. By setting up a life estate, having everything documented, like he does have, even though he is still alive, Mary gets a stick. This stick is called life tenant. If Mary should happen to pass away, this stick, before my dad would, okay, this stick goes back into my dad's hands. He's the grantor. My dad passes away. Mary has her sticks, but once she passes away, all those sticks become ours, us kids. So we have a reversionary interest. Another example of somebody who would have a reversionary interest is if, let's say Cameron owns a 16 unit building, and he rents out one of the units to me. He has a stick in his bundle of sticks that's called the reversionary interest, because eventually when I leave, that unit's going back to Cameron, right? So he has a reversionary interest. He's eventually going to get that unit back into his possession. So those are three entities for a test purpose that would have that reversionary interest. Now, these titles are also testable material. The grantor, the life tenant, which is Mary. In this case, Mary's life is the life measure, and then us kids are the remainder men. Now, when you look at this, there are some things that Mary can do, and there's some things that Mary can't do. Oops. She can't waste the property. She has to keep the taxes up. She has to make the payments. She has, if there are any. She can't just let everything rot and deteriorate. She still has to maintain the property to a degree, and she can't will it. Why? Because when she dies, it immediately goes to us kids, so there wouldn't be any way that she could will it. But she can sell, lease, or mortgage. I think if you were able to follow along so far, you probably would agree about the leasing. She can rent it out. She'll probably find a local farmer that would like to, rent out the ground or rent out the pasture. But how in the world can she sell or mortgage it? How in the world can she sell property? Because you'd be thinking, if she sells it, then how, when she dies, is it going to go to you kids if she sold it? Well, the life estate will trump any type of sale that she would do. And so this is what it would look more or less like if she did decide to sell. So she found a farmer that would like to purchase it from her. She would like to sell it instead of renting, because if she sold it, she'd get a lump of money up front instead of getting monthly payments over time, right? So she'd rather cash out now and get the money up front, and then instead of just dealing with the hassles of renting it every year. So the farmer, let's say, that's going to buy this 300 acres of crop ground, he's not going to pay full price because he's not going to own it forever. The farmer's only going to own it until Mary passes away, and when Mary passes away, it's going to go to us kids. So how do you think he would, or what do you think he would use to to justify spending X amount of dollars, or to come up with a purchase price? Close. What's that? Thank you. It's a little bit, I suppose you could think a little bit morbid, but that's what he's going to do. He's going to figure out how many years does Mary have left in her. Maybe I don't know if he'd say it that way, but he would have to figure out if she lived another 10 years, what would this ground be worth if I could own it for 10 years? So let's just say that's the case. Mary could live for another 10 years. Mary, right now probably would live longer. Yeah. You're right, Cameron. She has to let him know that this isn't a life estate, and that once I pass away, then this comes out of your hands and into the hands of the remainder men, which is us kids, or the heirs. You're right. So it wouldn't be a traditional purchase agreement. There would be some stipulations, and they'd want to have an attorney go through it with them. But let's say he calculates out that Mary has at least 10 years. So he pays her a price based on, if I buy it now and I only have it for 10 years, this X amount of dollars is going to make financial sense. Now, if Mary lives 20 years, he got a steal. But if she happens to pass away after 5 years, then it wasn't the best financial decision, but that's just how that's how the gamble worked out.
He's banking on rain, he's banking on gas prices, he's banking on everything in place.
So he is probably going to be coming out on the winning side because there's so many variables. It's such a huge gamble for him to give her X amount of dollars per acre, expecting that she'll live another 10 years. So it's going to be a very reduced price. But she's going to be willing to take it if she wants a lump sum of money up front. It's just like any type of payout. If you either can have it up front or take it over the course of X amount of years, there's always the penalty when you take it up front. So that's what she's going to have to deal with if she's going to go down that road. But chances are, again, she'll lease it out. She'll look at her assets, what she has, and see what's going to make the most financial sense, and then she'll just have to find somebody to buy or rent it from her that's willing to do that. So, yep, that's how a life estate works. Now, there's a second one in your book, and this one is called a pura trevi. Pura trevi. I think it's Chinese or something, right? Maybe not. So the pura trevi is very similar to a life estate, except when we get right here. Okay? So it's still going to be Pete, my dad, to Mary, except we have a different life measure. In a pura trevi, what you're going to need to remember is that the difference between this pura trevi and a life estate is that we have a third party as the life measure. So the length of this life estate is based on the life, not of Mary, but of a third party. That's the hang-up. So here I have Lou's life, and here is Mary's life. There's still the life measure, and whether we're talking about a life estate or a pura trevi, it's just that we have a different party than Mary. My dad, Pete, would create this. Yep, this would be how he would create this. This is the scenario I would put together, just maybe to help you, since we're on this subject of my dad and this life estate. Lou is my mom, okay? My mom and dad farmed that farm for 36 years, 35 years. My mom retired from the VA as a legal secretary. She worked there for 37 years, and she had a stable income and health care, health insurance. Some critical things for our family growing up. So if it wasn't for her, there's a good chance the farm wouldn't have made it. Back in the 80s, there were some times of farming where it just wasn't such a good road to be on. But my mom also grew up on a farm or ranch out by Huron. No, it was out by Kimball area. And so she's a hard worker. She could get on the combine. She could get on and help my dad with the farming, but then she also, like I said, worked. My dad could look at it as it was their partnership. It was those two working together that made this work. And when she died, that would conclude that life or that adventure. however you want to look at it, that journey. So he would, again, give it to Mary so she still had the income. She's still the life tenant. She's still the one that can sell, lease, or mortgage. But when my mom passes away, it automatically goes from Mary's hands to us kids. So Mary, like I said, can sell, lease, mortgage, and now she can will. Remember we talked about earlier in the life estate situation that once Mary dies, it automatically goes to us kids, so there's no reason why she could will it. But now it's not based on her life. She isn't the life measure. The third party is. So let's say my mom lives another 40 years, and Mary only lives 5. Mary can will this to her kids, so her kids now become the life tenant. They can sell, lease, mortgage, and will. Her kids can will it to their kids. And so let's say her kids, let's say Mary only has one kid, and that one child dies in a car accident 5 years later. So Mary dies 5 years into it. 5 years later, her child dies, and her child has willed it to her kids, which would be Mary's granddaughter or grandkids. Now they're the ones that are in charge of the life estate. And until Lou passes away, until my mom passes away, that's theirs. They're the life tenant of that estate. But once my mom passes away, then it goes to us kids. We're always the remainder men. Yeah. So what you're asking is, can he make Mary's child one of the third parties here? Instead of, yeah, he can use anybody he wants for Lou's life. He can use Senator Tim Johnson. So once Senator Tim Johnson passes away, and it goes to us kids. It doesn't have to be somebody like this. I just use this scenario to help tie them. It's a good question, because I'm making everything family here. And so, yeah, we can think outside the box. And yes. And so these terms, remainderman, life measure, life tenant, and grantor, are important to remember and know who's who. Do you have a question?
I lost you someplace on this. How can they sell it? How can, now, Mary can sell?
Mary can sell, or if her kids, if Mary passes away and now it's her kid, all they do is just substitute themselves for Mary. So they now become the life tenant. That's if, of course, my mom is still alive. So Mary's kids, let's say she has a son or a daughter named Kennedy. So Kennedy is alive. Kennedy now will become the life tenant.
Does that take you out of the loop then?
No. We're always here.
But how can they sell if you're always there?
Because they could sell up here. Remember? Mary could sell up here. They can sell down here. It's still going to be the same situation where they're going to buy it based on Lou's life now. They're going to have to take a look at Lou because she's the life measure.
She's the life measure.
Exactly. So this life tenant, like you said, can bounce around and do whatever until the life measure, whether it's here or here, passes away, and then it's out of their hands and it's into ours. It's into our grubby little fingers. So we're good? I think I had most of you up here. Then we kind of took you for a loop. Yeah, when I threw in that third party. But that's the nature of a pure Atre V, is that we have a third party as that life measure. Yep. Remainder men, person who receives the estate after the termination of the life estate. Now that's a textbook definition. That's kind of what you'd see on the test. It's unfortunate you're not going to have somebody there putting it into real world scenarios and converting into layman's terms. You're going to have very textbook type answers. reversionary interest. Remember that word interest? Think of the stick. Remember, like we talked about this morning, that possession, that bundle of rights or bundle of sticks? That's the future stick in a life estate that reverts to the grantor or the heirs upon the expiration of that interest. Again, textbook way of saying it, but for your exam, that's what it's going to look like. A dower and curtsy are interests of a spouse's in their other spouse's estate at the time of death. So a dower is the wife's interest in the husband's estate when the husband passes away, and the curtsy is the husband's interest in the wife's estate once the wife would pass away. So dower and curtsy. A non-freehold estate. If you look at the slide, you'll see that empty nest with the for rent sign in it. That's what I want you to think of when you think of a non-freehold estate. We talked about the leasehold estate. We talked about the freehold estate. And that's more of that ownership. That's for an indefinite period of time. We talked about fee simple absolute, defeasible, and so on. It's really what we're going to be dealing with in the real estate world. But when we talk about non-freehold, if we get into property management, that's the type of stuff we're going to deal with. Remember that nest with the for rent sign. So this has to deal with interest that's for a definite period of time. Like if I'm renting something for 6 months, I know when I'm going to be expected to vacate, when the 6 months is up, or 2 years, or 15 months, whatever it is. There's a definite period of time. So there's non-freehold. I see where you're going, but the thing is it's not for definite because we don't know when this person's going to die. So we have no end in sight. They could live another 5 years or another 25 years. But good question. So the life tenant is still going to be operating under a freehold type estate. This is the list of the non-freehold estates. You saw on the previous slide that it said leasehold interests. They can also be called leasehold estates. We'll see that when we get to the property management section. I don't want to for years is the first one. And this is an interest in a property. Again, we're talking about kind of these are our non-freehold or our leasehold interests for a certain exact period of time. And you'll see in the example, January 25th or 5th, 2009 to June 27th, 2012. There's no rhyme or reason. When you see a estate for years, it doesn't have to be for more than 1 year. It can be from January 25th, 2013 to February 9th, 2013. Doesn't have to be for years. This is just how the phrase is. So when we go through these, real quick, before you start trying to take these and somehow implement in your thought the last lease you were in and trying to figure out which one it would fall under, this really isn't describing different types of leases. We'll look at that when we get to property management. We'll talk about a gross lease and a net lease and those things. But this is just non-freehold interests. So if you really had to try and incorporate this into the real world, the current leases that people are in are more or less a modification or a kind of a hybrid of these first two. So you maybe start out on a year lease, and then once the lease term is over, if you're still there, it just switches to a month-to-month. That's a typical lease. So it's kind of a mixture of both of these, and if that helps you remember them, fine, but don't get stressed out when you see that there are some discrepancies between what an estate for years looks like and the current lease or last lease that you were in. So once that lease expires on a periodic estate in estate for years, there is no need to give any type of notice. So there's no need to give notice to terminate this type of lease. Once I hit that final date in the example, which is June 27th, 2012, once I hit that date, I'm gone. I'm expected to be out of the premises. If I am still there on June 28th, 2012, then what I have created is an estate at sufferance. And we'll look at that last, and you'll be labeled a holdover tenant. You'll have to walk around the city with the scarlet HA or HT. No. But a holdover tenant is a part of an estate at sufferance, and we'll see that here in just a little bit. The next one is the periodic estate. And that's where we have an interest from period to period. It continues from month to month, or it could be from quarter to quarter, or year to year. Okay? That's what a periodic tenancy looks like, or periodic estate. I sometimes will call it tenancy, sometimes I'll call it an estate. It means the same thing. Next, in a few days, when we get to the leasehold interests, it's these same four back up on the board, and it's except instead of calling it a periodic estate, they call it a periodic tenancy. Same definition. Instead of an estate for years, it's called tenancy for years. Same definition. Okay, so it'll be a little easy to remember because we're just swapping out estate for tenancy, and that is to come. So on a periodic estate, if I want to cancel that, or if I want to terminate the lease situation, I need to give 1 period's notice. So 1 period's notice on a year-to-year lease would be what? 1 year. Very good. If I wanted to vacate on a periodic estate that was quarter to quarter, I'd have to give 90 days or 1 quarter's notice to vacate. So the next one is an estate at will. And that's an interest in which somebody occupies with your permission for an unspecified or uncertain period of time. So when I think of this, I think of the Super Bowl. I'm going to have a Super Bowl party at my house, not the actual Super Bowl, but a Super Bowl party. I guess even though we could think of the where the Super Bowl is held at, the dome or arena or whatever. You can tell I don't watch a lot of football. But that they give this estate at will. But let's think about it as a Super Bowl party. Okay? I'm going to have a Super Bowl party at my house, and I'm going to invite all of you guys over. The party starts at 5:30, and then it's over when the Super Bowl is over. And we don't know when that's going to be, right? Could go into overtime. So it could be done by 9:30, 10. It could be done at 11:30. But once it's over, everybody's expected to just head out. So that's what an estate at will looks like. An estate at sufferance is when the Super Bowl party was over at 10 and I still have somebody sitting down on the couch at 11:30. They haven't left. It's an estate at sufferance. I joke that an estate at sufferance occurs at Thanksgiving, about 10 minutes into the arrival of my mother-in-law. I have an estate at sufferance. But I have a good mother-in-law, so. But you're still there. And like I said earlier, you're now considered a holdover tenant. So if you're there longer than the lease allows, or you're there longer than that Super Bowl party, then now what's created is an estate at sufferance, and you're labeled a holdover tenant. Next, we're going to look at the title and deed. There are some misconceptions out there that the title is like our car title, which is something tangible. But in real estate, the title isn't tangible. It's actually the deed. The deed is what is signed by the grantors or the seller. It's not signed by the grantee or the buyer. It's signed by the grantor. And that's the tangible proof of ownership. And you could look at it this way, that the deed gives that proof of title, which represents the quality of the estate. So before we go any farther, what I want to put up here for you is these two words, employer, and for this case we're going to pretend that employer has an OR in it, and employee. The employer is the one giving, and the employee is the one receiving. So I have the OR and the double E. Again, I know employer has ER, but for this illustration, we're going to pretend it has an OR. So the employer is the one giving the job, right? Employee is the one receiving. And that's going to help us figure out who's who when we see terms like grantor, grantee, vendor, vendee, lessor, lessee. The one giving is the OR. So the grantor is the seller. They're the one giving the house. The buyer is the one receiving. They're the grantee. Okay? We're going to see a few more of those as the days go on, but that will be something you're going to have to know the difference between. And for the most part, the owner or the seller is the OR. Okay? And the buyer or the tenant is the double E. Okay? So the lessor is the landlord in a rental situation, and the lessee is the renter or the tenant. Exactly. With the deed, we have what's called livery of season, and that's just another way of saying transfer or possession, and that's what's done with this deed. Again, the grantor is the seller, the grantee is the purchaser. And this is actually dates back to hundreds of years ago when possession was transferred from one person to the other. It was called livery of season. And so how it used to happen is that, let's say Carissa is going to give Dwight or transfer on May 25th, 1818. She's going to transfer 15 acres to Dwight, and he's going to buy it. So what would happen is on May 15th, 1818, Dwight would show up at the piece of ground that he's going to be buying from Carissa, and how they would simply transfer ownership over is Carissa would pick up a clog of dirt, and Dwight would stick out his hand and receive it. Just would pass dirt from one to the next. It's not that simple anymore. Hence, real estate school, 116 hours, because we have contracts, several pages of contracts. So, but that's where livery of season comes from. The deed must be executed, delivered, and accepted, and signed by the grantor. Please remember that it's signed by the grantor. The grantee, the buyer, does not sign that deed. It's the seller. Delivery and acceptance is necessary for title to pass. Those are the only two key words that you need to know for your exam. If you have a question, what's necessary for title to pass, just look down through A, B, C, and D, and it's delivery and acceptance. That's it. Recording the deed gives constructive notice. that the deed has transferred, or ownership, I should say, has transferred from one party to the other. It's recorded in the county where the property is located at. And you may have a question between constructive notice and actual notice. Actual notice is simply knowledge of who is owning what. It's knowledge of that the grantor is transferring to the grantee, or knowledge of the fact that the buyer is now the new owner. It's just mental knowledge. That's all it really comes down to. Constructive notice is different than actual notice, because constructive notice is the physical action of going down and recording that deed. That provides constructive notice. So you may see a blurb on actual notice, and that's really all that it is. The contents of a deed need to have competent parties, consideration, words of conveyance, the description of the real estate, any restrictions that are part of the real estate, the addendum clause, and the signature of the grantors. If we look in our book, though, we can look at an actual deed, and we can go down through the list, and I can point out some of those to you. So if you would turn to page 76. Page 76, we have a copy of a general warranty deed, and we'll talk about the difference between a general warranty and a special warranty deed. But first off, we see, number one, we need competent parties. And if you look at this deed, figure 5.2 on page 76, you'll see that number one are those competent parties. They're listed there. Number two says $184,000. That's consideration. You have to have consideration to have any sort of valid contract. And typically consideration is going to be like this, where it's money. We'll talk about the different forms of consideration later, but in this case, it's money. That's most of the time what it's going to be. Number three, you'll see, are the words of conveyance. It says, do hereby grant, bargain, sell, convey, and confirm to. And then we have number four, which is the buyer's name. Number five is the description of the real estate. That's the legal description. Lot 8, Block 1 in Confusion Hill. So that's our legal description. If we skip down almost to the middle of the page, number 7, these are going to be the restrictions. Talks about the covenants, restrictions, the easement of record. Number 9 is the addendum clause. And what you need to know for the addendum clause is the phrase to have and to hold. If you look at the paragraph that number 9 is in, on page 76, you see the very first 5 words are to have and to hold. That's the addendum clause. So the addendum clause is to have and to hold. To have and to hold is the addendum clause. And then you'll see number 10 to the right there is the signature of the grantors. Again, the deed is signed by the grantors, not by the grantees. One of the things that we have as a part of our transaction or closing is a transfer tax. It's usually paid by the grantor. Again, the seller. And this is the tax that is charged by the state to transfer that property from one party to another. It's typically 1% of the overall purchase price. So if you're really sneaky, you can go on to county and find out what the transfer tax was on the house, and that should tell you what the purchase price was. Okay? So if the transfer tax was $153, what was the purchase price? $153,000. So sometimes you can't locate the listing on MLS because it's sold. MLS will actually store the records for several years, but eventually they fall off. They don't hold everything that sells on MLS. So that being said, if you can't find it, you can find that out on county. It really isn't incredibly relative to the sale of the house, but it does help you get a good footing or foundation when you're meeting with the seller and they're telling you, this is how much I paid, or maybe they don't remember how much they paid. In our books, we start this discussion of different types of deeds. The first one is the general warranty deed. The general warranty deed starts at the bottom of page 78 and is up on page 79. You'll see the 6 warranties that are part of the general warranty deed. Please pay particular attention to the first 4. The covenant of season is the first one. And this is where the grantor or the seller declares that they are in 100% possession of the interests that they're granting. So they have all the sticks. The grantor has all the sticks that they're transferring. Okay? And they have all the possession. Let's say they tell you they're going to transfer these 12 sticks to you, but actually 4 of them they don't even have. They don't belong to them. That would be an example of color of title, right? So that's the first one, covenant of season. Quiet enjoyment, that simply means that they're guaranteeing you that the neighbors are never going to throw loud parties. No, maybe not. Exactly. So covenant or quiet enjoyment does not guarantee that your neighbors won't throw loud parties. Quiet enjoyment simply means that this house that I'm giving to you is yours. You're getting full possession. You don't have to worry about somebody coming at 3 in the morning and knocking on the door and saying, hey, get out of my house. Going back to our renting example, if Cameron is renting out a unit to me, he's also going to grant me quiet enjoyment. So from a property management perspective, that's applicable. Cameron's saying, Colby, this unit's yours, and I haven't leased it out to anybody else. It's exclusively yours. Okay? So that's what quiet enjoyment looks like. Freedom from encumbrances, number 3, says that there's not going to be any physical encumbrances or unpaid taxes or liens or any of that thing of those items transferring to you when you buy this house. Okay? Further assurances, number 4, this simply ensures good title. And if there are any things that come up after the fact, the seller is putting their neck on the chopping block and they say, we'll fix them at our cost. So if for whatever reason something pops or rears its ugly head after closing, we're going to take care of it as Mr. and Mrs. Seller. You don't have to sweat it, Mr. and Mrs. Buyer. We're going to handle it. So you see I have underlined that this type of warranty deed, the general warranty deed, is the best deed for the buyers because they get the absolute best coverage. But it has the most liability to the seller, especially number 4. If something pops up after the fact, it may not even have been the seller's fault. Could have been 2 sellers before that seller, or 2 homeowners before that homeowner, but the seller's agreeing to take care of it. Good question, though. There's no time limit on that. It's going to stay there forever. Well, and then if that buyer sells. Yep. If that buyer sells and the new buyer comes in and just gets a special warranty deed, then there's nothing there. Yeah. Covenant of season, it's saying that I'm going to transfer these 12 sticks. You're getting all 12 sticks at closing. Freedom from encumbrances is talking about these sticks that are outside of the seller's possession. So if a subcontractor put a lien on the house, that subcontractor now has a stick because there's a lien on the house because that subcontractor didn't get paid. The seller still has these sticks, and that's what the seller's transferring to the buyer at closing. These sticks belong to that subcontractor. So the first one, which is covenant of season, not talking about this out here. It's talking about this, what I have in my hand as a seller, I'm giving to you. And I have full possession of all these. The other one, the freedom from encumbrances, is talking about these outside sticks that could be floating around, like an encumbrance or the, like I said, the lien that is on the property that the seller didn't disclose. In the real world, the seller is going to have to take care of those liens before they close on it. The buyer should not be taking on any liens through this general warranty deed at all. All of those should be paid off and taken care of by the seller before closing. The next one is the special warranty deed, and this guarantees only during the ownership that grantor had it. It's not guaranteeing anything else. Other than that, it's pretty much just like the general. So let's look at it up here on the board. So this purple is the general warranty deed. So the house was built in 1956. This is January 25th, 2013, when we're closing on it. All these little dashes represent ownership. Different times the house was bought and sold. So the general warranty deed covers all of that. The special warranty deed only covers it from this guy to present day. That's it. Whereas the general goes all the way back. That's why it's the most liability for the seller, but it's the best deal for the buyer. And you'll see questions like that. Which one is the best for the buyer? Which one's the best for the seller?
Why would a seller want to do that? I mean, have with all the knowing, how would you do that as a seller? Guarantee all the way back from the house is built.
Correct. The seller's not going to have to go back and prove with paperwork. The closing company will do the title search and go all the way back. And so basically the seller will just sit there and wait for the title search to get done, and then they'll be notified, hey, look, back in 1976, so-and-so didn't pay a subcontractor, and so there's this bill sitting out there. I mean, that stuff will come up. Yeah, so that's the two differences between the general and the special. There's other types of deeds. There's some that are mentioned in your book. Again, I really want to cover what's more tied into the test. And with a bargain and sale deed, there are no warranties with the bargain and sale deed. It's pretty under the table in the sense the grantor or seller just implies that they have or had an interest but offers no warranty of title. So it's pretty risky when you do a bargain and sale deed. A quitclaim deed, though, so for example, we have a divorce situation, and they go before the judge, and the judge rewards the house to the husband this time. So the judge rewards the house to the husband, but on the deed is both the wife's name and the husband's name. So what they would do is they'd go down to the courthouse and they'd file this quitclaim deed, and all that means is that the wife is quitting her claim. You can almost look at it like she's giving her sticks up. So now that house is only under the husband's name on the deed. Does that automatically change the mortgage? No. It depends on the mortgage. We don't need to cover that. It's not on a test. But if that's a situation on a quitclaim deed, it's again simply the one party. In this situation with the divorce, the spouse is quitting their claim so that it's just the other spouse's name on the deed. Sometimes it's removed or used to remove a cloud on the title as well. It's a quick way to clean something up. Either remove somebody or clean up something that's wrong with the deed. Deed of trust or trust deed is something that we don't have here in South Dakota. There's two different types of states. There's a title theory state and there's a lien theory state. The title theory state, there is a trust deed that passes. In a lien theory state, there's a mortgage. So, what I would like to do is show you that up here on the board so that you have a clear picture of what this looks like. So, the title theory state, places like that are Colorado and Nebraska. Okay? Colorado and Nebraska are set up like this. We have the seller deeds to the buyer. And the buyer gives this deed of trust or trust deed to the bank. That's what they give to the bank. The bank, in turn, holds legal title. Kind of like a car, right? Doesn't the car title sit down at the bank until you pay it off? There's some similarities there. But this is where that trust deed or deed of trust comes into play, and that's with these title theory states. South Dakota, we're a lien theory state. This might mess with your mind just a little bit, okay? We're going to have some very similar components to the title theory state, but instead of this trust deed, there's something else. So we still have the seller deeding to the buyer, and the buyer still gives something to the bank. The bank, in turn, holds a lien on the property. Anybody guess what the buyer gives to the bank? Close. the buyer gives a mortgage to the bank. So really, we don't go down, at least in South Dakota, I don't take a trip down to the bank or down to my favorite lender and get a mortgage. And we use that lingo a lot. Even realtors do. You're not going to get your license revoked if you don't get this right when it comes to that. You may have missed the question on your exam, but the buyer actually gives a mortgage to the bank. They don't get a mortgage. They're going to pledge the house as collateral. Okay? That's what they're doing with the mortgage. And like I said, with the bank, there are certain requirements the bank has. Remember, they usually ask for a survey. The other thing the bank requires is an appraisal. And you know why they ask for an appraisal? The primary reason for the appraisal is so that the bank can justify giving you this much money. In other words, the appraiser goes out to prove that there's enough collateral in that house for the bank to do the loan. That's what an appraisal simply is. So the buyer gives the mortgage to the bank. The bank then holds a lien on the house. When the buyer pays it off, the lien is simply released. Anybody know what the Old English word for mortgage is, or how it's defined? It's two words combined into one. So we have mort and we have gauge. Anybody take a stab at what mort means? It means death. Like mortuary. Okay? It's death. Gauge is a note. So mortgage is a death note. That's what it is. So the buyer gives a mortgage to the bank. Some of the other not so common deeds are the gift deed. Gift deed is used to donate real property. We'll see things like in consideration of $1. Has anybody ever given a car away or received a car and we do it in consideration of $1? Things like that. We'll also see a form of this when we look at our contracts. There is a separate contract that we use to transfer personal property, things like the stove, fridge, microwave. And because that's considered personal property, it's not real estate, we have to use a separate form to do that with, which is called a bill of sale. We use a purchase agreement to transfer real estate. We use the bill of sale to transfer personal property. And so when we go through that bill of sale, it says, in consideration of $1, we're going to transfer the $5,000 Bosch fridge, the $6,000 Viking stove. But we don't go into prices and stuff, but it's just kind of comical that we're transferring these high dollar items for $1. But that's consideration. Remember, consideration has to be part of a contract for it to be valid. Correction deed is the next one. Correction deed will correct errors, like if the legal name is misspelled. A cession deed, or in South Dakota they call it a dedication deed, is used by a developer or subdivider when they're dedicating the streets to the city. So let's say Jeff goes in, and Jeff, you're out in Rapid, but you buy a nice chunk of property just on the southwest corner of Rapid City, and you decide you want to develop it. And so you get all the infrastructure, not the infrastructure, but you get all the planning and zoning approved. You get all the streets approved, and you start going in there. You get the dirt work done, get the curb and gutter in, get the streets in. But unless you want to make it a private neighborhood where it's up to you or the owner association to take care of the streets, you're going to dedicate it to the city. So now it's on the city's onus to take care of the street cleaning, removal of the snow, and all that stuff. So that's how you would do that, is through a cession deed. A sheriff's deed is what's used in like a foreclosure sale. Every Wednesday on the courthouse steps, at least in this county, there's a sheriff's sale. And so properties that have unfortunately fallen into foreclosure, they will sell those properties at that time. Has anybody ever been to the sheriff's sale? Usually not. On a sheriff's sale, the bank has X amount of equity in the house, or there's X amount left on the loan. And so usually the houses that are in that position, there's not enough room for like an investor to buy it. So the house is worth 120, but there's like $101,000 left on the loan. So for an investor to buy something like that and flip it for a profit, it's just not enough room. Although I have some friends who have bought houses on a sheriff's sale, but it's few and far between. It's not really a get-rich-quick program. The other thing with the sheriff's sale is that let's say you get the bid. By 5 o'clock that day, you have to show up with a check for that house. You don't go down to the bank and give a mortgage for 30 years. You're showing up with cash. So it's not really a market for every investor. You're exactly right. And you're right. So what you said is if there's any liens, if there's a color on the title, anything like that, it's going to transfer to you as the new owner. Because there are no warranties. The only warranty is that we're going to sell this house today. Kind of like an auction. Well, it is an auction. So, administrator's deed transfers the property of the deceased. Tax deed transfers property sold for unpaid taxes. If you ever sat up late at night and watched infomercials, maybe not in this last few years, but I remember about a decade ago, or there was a guy on there talking about how you can buy properties for cheap, and they're basically buying these houses that have unpaid taxes. So, executor's deed, transfers of property of the deceased. Again, there's no warranties with those. And then we have the different ways that we can take title. There's 4 different ways that a person can take title or ownership, or we could even look at it as a stick. The advantage to this is that you're going to need to know it for your exam. The one thing about taking title, though, is that when you get into the real estate business, if you're asked by a buyer, they're about ready to close on the house, and there's a question that comes up, how do you want to take title? It's something that you should not be answering. You should be referring it on to somebody who is either a qualified tax professional or an attorney. Okay? We're going to learn more about that later, especially when we talk about South Dakota license law and the Code of Ethics, is that we are obligated to stick within the scope of selling real estate or helping people buy and sell. Things like, how do I take title? Should I do joint tenancy versus tenancy in common? That's not a question you should be answering. So for now, you can lock this away in your short-term memory until you use it to pass the test. And after that, unless you're going to buy into a corporation and it personally affects you, it's a question that your buyer or even your seller need to be asking a qualified professional. That's outside the scope of our business. This slide that you're going to see first is concurrent ownership. And I want you to kind of tuck that away until we get through these 4 that we talked about or were introduced to us on the previous slide. Because concurrent ownership isn't really a way that you take title. It's just a way that, or it's just a form of ownership where we have 2 or more people that are involved. Again, it's where we have property held by 2 or more people. That's concurrent ownership. So let's get through these 4 entities, and then we'll go back to concurrent ownership and talk about that. So the first thing about joint tenancy And if you look on page 82 in your book, they have these 4 unities listed. They kind of have them in reverse order. The order I put them in spells out the acrostic PITT, P-I-T-T, like Brad Pitt. So, PITT, P-I-T-T, these all have to occur in order to have joint tenancy. You all have to have possession, equal interest, so the equal number of sticks. It has to be done at the same time, and your title reads that same way. That's the only way you can have joint tenancy. If one of those 4 unities is missing, it's not joint tenancy. Okay? Now, I am sure that in today's society, if I was to have an attorney draft something, I could alter this. Okay? We're not talking about those types of variables. We're talking about textbook statements and answers. So, for your exam, for education purposes, these 4, the PITT, all have to happen, all have to be a part of this ownership in order for you to have joint tenancy. So, I have up here on the board A, B, and C. These represent owners. Owner A, owner B, owner C. They all have a 1/3 interest. That would be joint tenancy, equal form of ownership. They also would have had to have this interest or ownership at the same time. Again, all 4 of those unities, PITT, have to occur to have joint tenancy. So if I had A, B, and C, and let's say I had a 20%, 25%, and 55%, that wouldn't be joint tenancy. I don't care if we took ownership at the same time and we're all on title, that would not be joint tenancy. That would be tenancy in common. The other thing about joint tenancy is that we have this right of survivorship. And it may not work this way with your brain, but it kind of went counter to how my brain functions. But this right of survivorship doesn't mean that if C wants to, he can will it to his son, his 1/3 interest. What right of survivorship means, if C kicks the bucket, his 1/3 ownership goes to A and B. So if C dies, A and B absorb his ownership under joint tenancy. That's what the right of survivorship is indicating, that those parties now have his or her interest. So now A and B would have a half. In fact, another point about joint tenancy is that it trumps a will most times and every time on your exam. So I don't care if C had an ironclad will saying that his 1/3 interest is to go to his son. If he's in joint tenancy, it's not. It's going to be split equally between A and B. That's joint tenancy. The next one is tenancy in common. Tenants in common, or it could be called tenancy in common. So please don't let that throw you off. Tenancy in common is again where I have 2 or more people coming together, just like joint tenancy. The owners have an undivided right. So let's say a mom owns a house And when she passes away, she wants to give a 1/3 interest to her son and a 2/3 interest to her daughter. This is going to be an example of tenancy in common. Undivided ownership or undivided interest. That's your key word. So that's tenancy in common. Now, a lot of times in a will situation, you're going to find this, where one party might get more than the other. And also in the test world, that's going to be your tenancy in common. It's going to be very difficult for a party to achieve joint tenancy because of all those little restrictions. So chances are you're going to find yourself in a tenancy in common scenario. Also, to protect for partners, if they want, let's say they're in a business venture, but they want to protect their family. They want to make sure their family's taken care of if something happens to them. Then the best way for them to form that relationship is through a tenancy in common. That way, let's say I have A, B, and C up here. And let's say they all take an equal ownership. Just like the PITT, or just like our joint tenancy. So they all have equal ownership, but if C dies, he can will it to his kids. Joint tenancy, remember, trumps a will. Tenancy in common does not trump a will. If C wants to will off his ownership to the kids, by all means he can do that. Now, while we're on that subject, if I'm part of a partnership, okay, let's say it's me, Ken, and Kelsey. We form a partnership together. But Ken and Kelsey, they know me. Let's say we're lifelong friends, but they don't like my snot-nosed son. They think he's a brat. And they know that my intent would be to pass everything on to him. But they feel like, look, if Colby's son gets ownership of this or gets a 1/3 interest, he's going to destroy the company. He's going to bankrupt us. So if you want to protect your interest, out of these two, which would be the best one for you guys to enter into with me when we put together this partnership? Very good. So if a business wants to protect their interest, we would want to do a joint tenancy. So that if I pass away, Ken and Kelsey absorb my 1/3 interest. Okay? The next one is tenancy by the entireties. This is something that we don't have in South Dakota. This one's a little simple because it's husband and wife. That's all it is. This isn't Jeff and Adam entering into a partnership. This is spouses. This is husband and wife. And in this, a husband has 100% and the wife has 100% ownership. So there's no question what happens when one spouse dies and the other one is still alive. It's all theirs. And it's also the best way for husband and wife to own property is through this form, tenancy by the entireties. The last one is kind of a little bit opposite because it's called severalty, but it's not several people, it's actually one. It's kind of the opposite, like I said. So severalty is one person, is that it's also one entity. So if I have a corporation such as Kraft or Kmart, that's one entity. It can have ownership in severalty. Even though there's several staff members, several employees, and so on, they can still have ownership in severalty because it's recognized or it's looked at as like one entity. So that's how severalty works. I said I wanted to kind of skip over that concurrent ownership and then come back to it. And this is the reason why, because sometimes we get confused thinking concurrent ownership is one of these 4 ways to take ownership, and it's not. Remember, concurrent ownership is just any form of ownership where you have 2 or more people that are involved. Okay? So if you had a test question that said, out of these 4, which one is a form of concurrent, or which one is not a form of concurrent ownership? And they gave you A, B, C, and D. So joint tenancy, tenancy in common, tenancy by the entireties, and severalty. But severalty is correct. So joint tenancy, is that concurrent ownership? Yes. Tenancy in common? Tenancy by the entireties? Yes. And this one is no. Severalty is not a form of concurrent ownership. Community property. This is not something that we have in South Dakota, but how community property works is that if there is a divorce situation, the property that's acquired during marriage is split down the middle, or it's considered community property and it's up for grabs. Okay? So if I owned, well, let's use Cameron because he has that 16-unit building. Let's say he owned that before he got married. He owned the 16-unit building before he got married. And he lived in California where there's these community property laws. He gets married, buys a Ferrari, him and his wife buy a house, and they buy a second home in Southern California. Something happens, and they end up finding themselves in divorce court. Everything that Cameron and his wife acquired during marriage is going to be considered community property. And like I said, that's going to be up for grabs. The 16-unit building, though, that he had before marriage is Cameron's. That's his and his alone. He's going to walk away with that. Also, let's say Cameron has a rich uncle, and his uncle dies and leaves Cameron with $50,000. Cameron uses that to buy a larger sized boat. That boat is also Cameron's. That wouldn't fall into community property because he didn't use his money and his wife's money to buy it. He used it from his inheritance. Okay? So that wouldn't fall into community property. Partnership. This, I think if you just sit down and think about if I'm Naomi and I'm going to form a partnership with somebody, I'm going to do it this way. It's going to be me and somebody else, partnership, right? There has to be more than one person to do a partnership, unless you have a really good imaginary friend. So 2 or more people. You have a joint business venture. You're joining in a business venture, and you're doing it with the intent of making a profit. That's a partnership. Pretty simple. So there's 2 or more going into business with the intent of making money. I don't know many partnerships that you're going into business to lose money, but a partnership, I alluded to this a little earlier, but if you have a trade name like ABC Partnership or Kmart or Kraft Corporation, you can have ownership and severalty. You're considered a single entity. It's when you have the individual owners' names in the title is when you're going to have to look at tenancy in common or joint tenancy. So why couldn't you do tenancy by the entirety? Why did I leave that one out? Because that's only for husband and wife, right? And then finally, we have our homestead laws. I'm just going to use a blanket statement to discuss that and then talk about what's specific to South Dakota, how our homestead laws work here. But really, it's there to protect a family's place of business, or I'm sorry, a family's home, not place of business, otherwise it'd be called business-stead laws. This is homestead laws. These are there to protect your primary residence. And in italics, you'll see that it's protection that you receive from judgments that are out there, and that creditors can only take so much from a homesteader. So if you're forced to sell your house because of the financial woes you found yourself in, creditors can only take so much. In fact, in South Dakota, the first $30,000 that you receive in proceeds from your sale is yours. You get to keep it. The first $30,000 is yours. That allows you to get back on your feet. Anything outside of that, let's say you made $35,000, the $5,000 on top of it would have to go to start paying off the creditors. Now, there are some exceptions. If you have unpaid real estate taxes, you have to pay that. So if, let's say, you sell the house and you have $30,000 in profit, out of that, you're going to have to pay your real estate taxes. That's a government thing, right? You can't win that battle. If there are special assessments, remember that has to deal with taxes as well. That's underneath that taxation power that the government has. Real estate mortgage. South Dakota, remember they put a lien on your house. That's something that's going to have to get paid as well. If there's money left over out of that $30,000 after those three things are taken care of, you still have to take care of mechanics liens. If there's still money left over after those four entities or four bills are paid, you get to keep that. Again, that's part of that homestead law. So you can't use a homestead or use that on like you having to sell your vacation home out in the Black Hills. It's on your primary residence. But that's part of the South Dakota homestead laws. It's when it comes to the $30,000, it's not necessary for your exam to remember that exclusion. Just know that one italicized phrase that I have in there, it protects you from those judgments in that creditors can only take so much upon the sale of your house. Are we good?